Welcome to Employee Termination Tips. My name is Christopher Neufeld of Neufeld Legal, and in this particular video, we're going to discuss the information shutdown that employers institute upon your termination. So what exactly is an information shutdown? It's when the employer shuts down your cell phone that's been provided by them and your email access. And this is very problematic because all too often, employees have relied upon that cell phone and that email service to obtain important information that is directed towards them as an employee from their employer and is not meant to be retained, or at least is meant to be accessible to them in their personal capacity. Nevertheless, what the employers do is they take the premeditated step of cutting off access and thereby denying the employee or now former employee access to materials that should be in their possession. For example, pay statements, contracts, communications that normally would have gone to them in a written form and they could have retained at their home office have now been sent to them by email. And since they did not anticipate this termination, or should have been more cognizant in anticipating a possibility of termination, had not transferred those particular files to a secondary system. And that is a problem. And it is something that employees, when they get terminated, need to deal with promptly. So a couple things. If it's possible, before you lose access, and you have either some awareness as the possibility of being terminated, you should begin the process of transferring those files and those texts and communications on your cell phone that are appropriately personal in nature or were provided to you from the employer to yourself in your personal capacity as an employee and as an individual who should have access to those, such as contracts, pay statements, recommendations, notices. Those items should be transferred as soon as possible to another system. Now, if that's not possible, what you're going to have to do is immediately ask your employer to have those transferred, because those documents are important for purposes of determining whether or not you should accept their proposed termination and severance pay package. Otherwise, your lawyer is flying blind and you're flying blindly. Now, if your employer is going to be objecting to that, there are problems with that for your employer, given the fact that much of this information or other information based on your particular employment standards legislation of the jurisdiction within which you are working, does provide for specific information to be provided to you by your employer. And they cannot deny you that information. And what happens all too often is employers are unaware of this or are opposed to it, and they say, well, I'm just going to simply proceed as I feel appropriate. That is problematic, and that impedes your ability to make an appropriate determination. So, what do? Well, if you haven't been shut off, then you need to make the transferences that are appropriate immediately. There are apps that allow you to transfer stuff from your phone over to another phone. There are other programs that allow you to effectively transfer emails and attachments from one email server to another email server. And the fact of the matter is, this material is properly material that should have been in your possession. It was sent to you from your employer to yourself in your capacity, not in your working capacity, but as an employee to be retained by you outside of the office. And it is because it is to be retained outside the office that it is sent that way, way, and it should be possible to obtain that material. And the fact that your employer has taken the liberty or made the suggestion that they send it to your office email in many ways is inappropriate. The employers should not be sending such emails to your business email. They should in fact have sent it to a personal email that is outside of your system. They should have policies to that effect, but naturally they don't. And why do they not have that? Because it is in effect to their advantage. Because they know that with limited information, you have limited ability to know the full scope of your rights and the full extent of their vulnerabilities on a legal front. Because when lawyers have access to all the information, they can make better decisions on your behalf and have better legal challenges to what the employer is doing. So, when that is the case, you need to address it. Now, at the same time, if all of a sudden you lose access to your phone, you lose access to your email, and you're about to be called into meeting, well, you know what that means. They've preemptively shut you down. So when they've preemptively shut you down, what you should be doing is looking to get access to those materials. They want you in there now for an exit interview. And they want you to accept the package that they're going to provide you with. The only problem is they're going to talk to you and try to extract information for their benefit. But what are they going to do for you? You go into the meeting, you've already been shut out, but they are not providing you with access to the materials that should be provided to yourself. So you go in, what do you tell them? Why am I shut down? And if I'm being shut down, please provide me with immediately copies of all materials that should have been in my possession or should be available to myself for purposes of making this determination. Because doing that is what you need to do to actually be able to reasonably review your situation, hopefully with legal counsel, and make the appropriate decision so that you could come out of this termination at least in the best position possible. It's not going to give you your job back. That's what it's not going to do. But what it's going to do at least is going to give you that much more certainty that the termination and severance package that you ultimately take is going to be appropriate in the circumstances. And that's what you should be looking for. You're not looking for some great Hail Mary where things are going to turn around. That's almost never going to happen. So what do? You do the next best thing and try to get the best out of the current situation. And if you have the opportunity to retain access to your accounts and you've been terminated, you need to move quickly to take what information you are permitted to. So you might want to talk to a lawyer right away. But there is information that is permissible in those systems that is meant for yourself, that the employer has meant for you, that you actually need. You actually need some of the material that is sent to you in your business account that is meant to be shifted out of your business account and retained by yourself after your employment. And that is the pure and simple fact of the situation. Similarly, they cannot simply look to delete stuff. That's inappropriate unto itself. But what happens? You lose access. They shut it down, and then somehow it might disappear. I'm not trying to put in too many conspiracy theories, but stranger things have happened. But what you need to do is take swift action and swiftly call the appropriate employment lawyer to engage with and see what other steps you need to do to advance your position and not put yourself at a deficit in these arrangements. You have to move quickly and effectively and get the right situation for you. And that's what it's about. Getting the right situation for you and your family and moving forward. So when you get shut down, you know what to deal and how to deal with it. And that's what you got to be doing in these kind of scenarios. Thank you.